That wasn't a pre-hearing, that was a status conference, so it had already been.
Well, I have it as the pre-hearing. I'm looking at it on Earth.
Oh, I guess
Oh, it was the 5 dockets. That's
we
why.
did call it a pre-hearing. Yeah.
I just need the appearances at this point.
Oh, I forgot the screen sharing. No, I forgot something.
Okay.
Well, good morning to those who've joined us so far. Just curious if David Shea is in the waiting room. I do recognize that name, but I'm not sure who they're affiliated with. Anyone help me out with that? Sounds like a
Good
familiar.
morning, Judge. It's Jordan Hamiden. And yes, David Shea is with us, and he's my colleague.
Oh, okay, great. So I'm getting an echo on your microphone. If you have two laptops or two mics running at the same time, that might be a issue with you guys.
All right, how is that?
No, still getting the echo there. So if you, I think you probably have that witness, but that one's muted. Probably maybe the speakers are on the witness laptop. Could be.
I am currently muted, Judge.
Okay, Judge, how is that?
That's better.
Okay,
Yep.
good. That's the way we'll run it.
Okay, great, thanks.
You bet. Make sure it's all turned all the way. Thank you.
I'm also seeing Eric Austin joining us. That's another name. Sounds familiar, but it's the memory game I'm failing.
Eric Austin is Walmart's witness.
Oh, the witness. Yeah, okay. Great. Thanks.
Ah,
Okay.
Sorry, I should have muted that.
It's all right. Well, the others are slowly joining in, so just be patient. We'll get them in here eventually. Hmm. Oh, looks like we have all the parties have joined us. We may have a few more witnesses that will be joining after we get started, but I think we can get started with the preliminary matters here. And I'll just be letting people in as when it doesn't interrupt us. Good, I just wanted to make sure we understood, in case you are using a background for your on your screen, just want to turn that off. I appreciate that. Otherwise, I think we're good to go. Oh, oh, let's get started. We'll get on the record. Welcome, everyone. This is Docket 4220, UR 127, the application of Northern States Power Company, Wisconsin, for authority to adjust electric and natural gas rates. My name is Michael Newmark, the Administrative Law Judge for the PSC. We're here on Zoom for the party hearing session. So we have the applicant and commission staff and interveners ready to receive their testimony. We have already had the public hearing sessions on September 11th up in Eau Claire, and we have received written public comments up until yesterday. That was the deadline for filing that. So at this point, really have nothing else to review on the notice of hearing. So why don't we proceed to take appearances? Just display the service list here. And like I mentioned, I think in the email where I presented this to the parties, this is the list we use to serve the final decision, and we've been using to serve other official documents. So just want to make sure the list is complete and correct. So just let me know if there needs to be any adjustments. All right, I do have a pen here. Okay. One of the few rare commodities nowadays is a pen and piece of paper. All right, so let's have appearances then, starting with Citizens Utility Board.
Good morning, Judge.
Oh, just getting a little echo there.
Let me try again. How's that?
You need your speaker.
I think it was okay. Try one more time.
Good morning, Judge.
No, I still hear you. Yeah, so let's go off the record. We have a
So
possibly
yeah, I'm muted, but if I turn, you need to use it.
Okay. My speaker's muted.
there might be an extra speaker in the room.
Mute your mic.
And we can hear the other person there.
Yep. Judge, how's this?
That sounds better. Yeah.
Okay, we're finally figured out on that. So,
Okay, so I'm sorry. So this was, I thought it was Cub that was having the problem. Is that
I did too.
okay? You both okay, right? I missed that. All right, great. Okay, so we're good to go. Let's get back on the record. So who do we have for a Citizens Utility Board?
Good morning, Judge Daniel Narvey, appearing for Citizens Utility Board. And with me today via Zoom are witnesses Corey Singletary, Jeff Adams, and Dr. Steve Coyne.
All right. So actually, I didn't have Dr. Keim on the service list. I'm not sure if you requested that or not. So right now, it's just the three individuals for Cub at this point.
Yeah, I think the service list is fine.
That works. Okay. All right. So we'll move on for IBEW Local Union 953.
Morning, Judge. Nick Weber appearing here for Local 953.
All right. Great. Thanks. NSP. So we'll take NSPW, careful unmuting there.
Thank
Who's
you, Judge.
appearing?
For NSPW, it's Jordan Hamiden and David Shea of Michael Besson Friedrich, and we have all of our witnesses present in a breakout room on the YouTube link, and we'll bring them in one by one for their testimony.
Okay, great. Yeah, I guess I'd seen a few of them. Oh, I see. So they appear. Oh, that's interesting. I don't see them in a room, but that works. Okay, we'll leave it up to you guys. How about the Public Service Commission?
Good morning, Your Honor. Stephanie Bedford, Assistant General Counsel, appearing on behalf of the Public Service Commission.
All right, thank you. Renew Wisconsin.
Good morning, Your Honor. Sharif Halawish for Renew Wisconsin. Also with me is Andrew Kell and Ben Belkkey.
All right.
I'm sorry, is Andrew Kell and?
Ben Belkkey.
Thank you.
Yes. So off the record, Sharif, you are a little muted in your volume. So if you just
I'll
speak
try to
up
fix
for-
that.
Yeah, maybe just getting closer to the mic would be helpful. All right. So how about US DOD?
Good morning, Your Honor. It's John McNutt. It's MCNUTT on behalf of the United States Department of Defense and all other federal executive agencies.
All right. Can you turn your camera on?
Oh,
There we go.
sorry, right here, Judge.
There you go. Okay, great. Thanks.
I wasn't sure if we were blurring or not blurring, so there's my basil plant in the background and my very, very dirty windows.
Okay, well, we've noted that, yeah, we just want attorneys to keep their cameras on in case you have an objection or, you know, as the course of the hearing proceeds, it's best to have you visible there. All right,
That's
great.
fine.
Okay, so Walmart, who do we have representing Walmart?
Good morning, Your Honor. Stephen Lee from the law firm of Spillman, Thomas and Battle, appearing on behalf of Walmart, and appearing here today as well as Eric Austin, Walmart's witness.
All right, thanks. And Weeg.
Yes, good morning, Your Honor. Steve Heinzen on behalf of the Wisconsin Industrial Energy Group.
Okay, great, thanks. All right, so let's go off the record. We'll just do our preliminary, next preliminary item. Should be familiar with the offered evidence list and the comments there too. First, we'll just deal with whether the list reflects the current status of the filings here. Hang on, let me just adjust this. On my version of the list, I've tried to indicate who witness has cross, which witness we expect to see cross, and any timing requests. You haven't seen that. I just added that after, but it just in terms of the list itself, if it reflects the current state of the filings, let me know if there's any corrections I need to make. So we'll start with the applicant.
That looks correct to us, Judge.
Okay. And for Cub.
The list looks accurate, Judge. I don't know if you want to wait. I had a couple of questions about your comments. I don't know if you want to deal with those now or
We'll take that after we've just make sure the list is correct. Yeah, thanks for asking. How about local 953? Any questions about the file? That really nothing to ask about there. So we have one filing and look good.
No questions.
Great. Renew.
No questions, Your Honor.
DOD, there's no filing. How about Walmart? And we have the correct
Yes,
representation.
Yes, Your Honor, that is accurate.
And Weeg.
Yes, Your Honor, this is accurate.
Okay. And commission staff, how does the list look?
Yes, the list is correct.
Okay. All right. So now I can entertain questions about the comments. Anything from the applicant?
Yes, Your Honor, I've got a few comments. Or questions rather. Haven't had a chance to review this in as much detail as I wanted to since receiving it, but my first question will be with respect to there's several notes here that the exhibits need to be refiled to comply with FMO 4A6, which I believe is limited to putting a disclaimer on the cover sheet of the exhibit saying that, referenced items are not record evidence unless attached as an exhibit. Is that correct?
That's what it means, yeah.
Okay. So that's easy enough. Also, the ones that are struck are things that have already been taken care of, correct?
Yes, yeah. They're just showing that there was an original, so we can track that while we're at the hearing. When I send out the received evidence list, it'll have only the latest filings that will go into the record. So you'll see those stricken items removed from the final version of this document.
And then all the refiled documents will have some kind of a designation at the end of them to indicate that they're refiled, correct?
Yeah, so the FMO will tell you the
Yep.
version ID. It's an R for the first revised filing, right? So make sure.
Okay.
So I didn't, in the past, I've kind of given you all the instructions on how to refile. Now I'm just expecting that parties and staff will follow the FMO, and refiling is subject to the other requirements that pertain to the refiling process.
Okay, understood. Is there a mechanism, Judge, whereby if you make a reference to the FMO section that's the subject of the fix, and we still have a question, is there a mechanism where we can ask you or email someone? Is that just an email?
Yeah, so the first point of contact for any questions is the assigned commission staff attorney. That's one of the first items on that FMO. So
Okay.
you can contact staff attorney, and if they can't answer the question, they'll ask me. This way it just keeps sort of the one-on-one contact to a minimum with
Sure.
me. If I do get an email, which is really not authorized by the FMO, but if I do get an email from a party, unless it's very simple, straightforward question, I'll basically I'll reply to the entire service list. This way everyone has notice of it, but also it could be a question that other people might have. So it would cover, answer their questions in advance. But yeah, the process which is authorized here is that you contact the staff attorney first. If they can get through to me and I can get the answer to you through them. But if we need to have a deeper conversation, we'll cross that bridge if we have to.
I think my final question, Judge, is you had made a notation on the exhibits for NSPW witness Goodenough's exhibit, and indicated that you perceive that to be over redacted.
Right. Okay.
I
That was
don't know
actually just a
before-
reminder for myself. I don't know if I think I got my question answered through for staff that this does not appear over redacted to staff. So
Okay.
and I guess I mean I think if in this round, in this year of rate cases, I'm going to accept what parties have filed for these fuel cost dockets, except fuel cost documents. There's one applicant that I think did over redact their exhibit. I'm hoping we can maybe get some sort of come together with some sort of consensus as to how we can file these documents or standardized for all 5 utilities, so that we know what we're looking for and then it's in the same format. But I'll let staff initiate that. But I think in terms of the Goodenough exhibits, didn't appear. It appeared like the lines that needed to be public were public. And comparing them to other utilities that are filing similar information that's consistent with those. So I was kind of comparing and contrasting those to make sure we're consistent across the different dockets. And there is one utility, but it's not NSP. There's one utility that didn't file in that way. So yeah, I can delete that note and it won't apply to to this case, so you can
Okay.
ignore that.
With that, Judge, I think the applicant's satisfied that it understands what it needs to do, and if we have any questions, we'll contact Attorney Bedford. Thank you.
Great. All right. Thanks. Okay, so I'll move on with Cub. Any questions? You did indicate. Sorry.
Yeah, two questions. Starting with Dr. Kimes' surrebuttal. There's a reference to FMO section 3 sub D sub 4. I'm wondering if this is just a case of not inserting a couple of NREs, because I did notice that it was missing some, but the citation is to a section that's about this citing discovery responses. So I just wanted to confirm if that's what you were looking for, the NREs.
Oh yeah, I think that's correct. Let me make sure. Yeah, I did see a number of the articles that weren't censorable. Right. Yeah, that you're right. So it is the NRE disclaimer that needs to be corrected with the kind
Okay, understood.
testimony. Yeah. All right. Thanks. Anything else?
The second question is for Mr. Singletary's Exhibit 4. And I think we figured this one out that it doesn't have the cover page for it's a book or a very large PDF. So just wanted to confirm it's the cover page is what you're looking for us to add.
That's right.
Okay.
Yeah, there's like a title page. That's essentially what we're looking for. Yeah.
Got it. Okay, that's all the questions for Kell.
Okay.
Thank you.
And Renew, any questions about the comments?
No, Your Honor.
Okay. And how about Weeg? Oh, I think there is one for is there one for Walmart? Yeah. Oh, there's one for Walmart. I think that's the NRE disclaimer.
Okay, yeah, I was wondering, Your Honor, what that was referencing, because it's asking IVA4 says to offer any document already filed on ERF in this document, but not filed as an exhibit, refile that document as an exhibit. If I'm referencing the FMO correctly.
Oh yeah, that's the wrong number. Oh well. Yeah, I think we're looking at oh, that might have just been maybe a misplaced comment altogether, because I didn't.
Because it was filed as an exhibit and it has a title page.
Right, it's definitely the wrong note.
Okay.
But I don't think I had any comments for this exhibit. So when I looked at was it the Power and Light case you're also in? I didn't see a problem with that. So I think that may just be a misapplied.
Okay.
Yeah, I don't know why that's in there. Okay, yeah, thanks for pointing that out. Okay, how about Weeg? Any?
Yes, Your Honor. I have a couple questions. In connection with, I guess, both rebuttal and surrebuttal, I understand that it is you're referencing FMO 3D4, which is citations to response to party discovery. And I don't believe there are any such citations in the rebuttal. There is one in the surrebuttal, and there are a couple in direct, and you haven't identified direct as needing to have any corrections. And so I wonder whether or not It's possible that it should have been direct and not rebuttal, but
That's certainly possible. Okay, thanks for pointing that out.
and then in connection with that, a question I've had for a bit of time here, but all of the Public Service Commission staff data requests go into a single discovery, DRR, right?
Yeah, let me just explain so it's for a rate case, the staff can choose to put in what it wants to in the DRR exhibit. So this is was clarified here, but
yes, I do remember having read that. How do we as a party know which data requests are going to be put in? Like at this part of the case still, how are we to know what is going to be in that and what will not be?
Well, so we're talking about, so the issue with yours is a party-to-party discovery citation, isn't it? So
there is, yes, but I do have I have a fair amount of citations to responses to staff's requests.
Okay.
And another question that's very related is that the utility files a lot of material in connection with their filing. That is not a formal request, but it's a file this with your filing. And we have one reference to that as well. And I don't know how best to handle that.
Okay, so I'm glad you're asking this. I'm glad we can review it. So because of historical anomalies, the CPCN process in terms of these exhibits is different than the rate case process. The CPCN process, the staff puts in all data request responses into its exhibit. So all data request responses are part of the record. In the rate case process, staff is handling that differently and has the discretion to put in responses as it sees fit. So the way it's explained in the FMO in the special, so in order to accommodate that, we've developed these special exhibit regulations in the FMO. Let me just see if I can get the microphone on the screen. And what the basics of that process is if you want to cite a data request response, staff should be doing its best to get that data request response in with its direct testimony, the data request response exhibit that lists all of the documents that it's going to offer, all the responses that it's going to offer for the record would be in that exhibit. That should be in its direct. And it may be subject to change and it would, to add more, but basically you have a touchstone there, at least, after direct is filed. Before direct is filed, you could contact staff and ask them, do you plan on filing this one? And if they do, you can just cite to it as if it's already in the record. It's already in the exhibit. So just use the exhibit naming convention and say, oh, I want to put in, MAR 3.2. So you just cite to it in your direct. And staff's told you they're going to put it in their exhibit, so you're all good to go. If staff says they're not going to put it in, then you'd want to, and you wanted the commission to see it, you'd want to offer it as your own exhibit.
Okay.
And similarly with the applicant may choose to create an application exhibit. So in a CPCN, they're required, they put in all their application documents into their application exhibit. And because it's coming in earlier in the process, people can then, know what is going to be in the record for that. But in a rate case, the applicant has the opportunity to add documents into its application. So it may want to put in the IDRs, the initial data request responses in its application exhibit if it wants to. So then you'd see those already being offered for the record, and you can just cite to them in your testimony Otherwise, you could offer that as, if you want the commission to read it and see it, you could offer that as your own exhibit. So, and the same would go for a party-to-party discovery. There's no automatic way of getting that into the record, so you'd want to offer that for the record as an exhibit. So if you're not offering it, you're just using it, to show the source of the witness's information for their testimony and their analysis, you can just put the NRE disclaimer on it. So just that way, it's always distinguished as to what's in the record and what's not.
Okay, no, that's helpful. So if staff is not going to put it into their data request or their exhibit, and the utility is not going to put it into its application exhibit, just treat those then as party-to-party discovery requests.
Right. Well, you get to decide whether you want to offer it or not.
Right.
Yeah.
Okay.
And I can tell you, I can just give you a screen share of this. So we're at the special exhibit section, and it's listed. Number 3 is application exhibit, and number 4, no, where is this? Number 5 is the data request exhibit section. So, and I think in the citation section, it gives you those instructions that you can contact staff to see if they're putting a document into their exhibit or not. So kind of gives you a heads up about what to expect in that process.
Okay, that's very helpful. Only 2 more questions, I think. If decide to, when I correct one of the citations, want to make it an exhibit, can I just make it the next exhibit that's in our, that would be offered by our witness? So like we're up to Pollock 8. If we wanted to make it an exhibit, Pollock 9.
I think that's fair. I think it's already been cited. Well, I mean, it's already been referenced, and yeah, if it's a data request response or a document that the utility is filing, I don't expect there to be a lot of controversy with you offering that for the record. So if you want to identify that now, and then it can fall under the process, which you can just file it, and because it's already been offered, I would say we'd probably want to offer it and receive it now, and then it won't be subject to any kind of motion practice at that point. Technically, if you just file it after the hearing, you'll need to file it with a request to offer post-hearing evidence. So,
okay,
no,
that's helpful. And not prepared to offer that right now. So I appreciate the instruction there.
Yeah.
And then finally, I guess the last question is on Exhibit Pollock 2. All Pollock 2 is a listing of the many proceedings in which Pollock has testified over the years. And so I'm not sure I'm not sure if that was an intended note for some necessary correction.
Yeah, I guess because it does reference the document, it's the testimony filed, I'm assuming, is what is being referenced here, the direct testimony. So technically, I mean, it could, just to make sure we're clear about that, just to put the NRE disclaimer on the cover page would be
okay.
Just to make sure we have that all buttoned up, but it's not being offered for the record. It's quite obvious, I know, but
no, that's okay. No, easily done. All right, thank you for that.
Sure.
And that's all the questions I have.
Okay, great. All right, commission staff, any questions?
Yes, Your Honor. Just one clarification. You had made a comment on Justin Adams' surrebuttal testimony, and I just wanted to clarify that when I looked at that testimony, it appears that we're missing a citation to witness Kimes' testimony, which is referenced, and I just wanted to make sure that that's what the issue was and that there wasn't anything else we needed to correct.
No, I think it was just a simple citation, right?
Okay, thanks.
Yeah.
And I'm sorry, excuse me. I do have one more question. That is, when we were talking earlier, I just noted that it appeared that the notes that you put onto the rebuttal testimony may have been intended to be on the direct. But
Yeah.
I didn't, close that circle to know whether or not, yes, I should refile a direct and not the rebuttal.
Yeah, I would just apply the original comment to the direct instead
Great.
of. Right.
Okay, thanks. Yep, that's great.
Okay, I'm just gonna note that for my. No, I turned yellow. Note that for my reference here. Okay, great. So, okay, so let's now review. So at this point, the directed rebuttal, there's been an opportunity to file requests to strike those documents. That's passed because the surrebuttal deadline's already passed. Surrebuttal, there's no such deadline, and that deadline's today. So I was going to ask if there are any objections to any of the surrebuttal or filings that have come after that, and let's get on the record for that. So let's get on the record. And any objections to the surrebuttal and accompanying exhibits? Go ahead and chime in, anybody? No? Okay. So I did have a question. It's kind of a legally question here. I'm just gonna pose that for the applicant. It deals with Ashman's surrebuttal. And there are no objection to this, but I wanted to point out that on page 2 of the surrebuttal, the footnote 2, it's a sort of a complicated reference to the Alliant rate case, the Wisconsin Power and Light rate case settlement. And I just wanted to be sure that I had my doubts in terms of the probative value of raising the Power and Light rate case settlement in order to discuss Cub's position in this case with respect to this is the earnings share mechanism treatment that's being proposed by the parties in Power and Light settlement versus the sort of what was considered a one-sided true-up of the vegetation management costs or in this case. And I guess just to get with all that background, it's a pretty complicated setup here of the facts, but I think with that background, the idea is that when we look at a rate case settlement without having the settlement document and knowing the intricacies of the compromises made by the parties to the settlement, I think the probative value is pretty weak in order to just cite to that without having more information. And I just wondered if the applicant had any more thoughts about that. No one's objecting, but I think I do have some concern about just kind of noting a settlement document in order to use that as the basis for an argument here, without having the document and without having sort of the background as to what was compromised in that case among the parties' positions, raises more questions than it seems to answer. So any thoughts from the applicant about that?
Judge, I think, we've reduced it to a footnote, which I think is a concession about the extent of its probative value. We just thought it was worth noting. We also realized that, as Ms. Ashman put in her testimony, that these settlements are comprehensive. And so we've acknowledged that. So I think it's, it can be given the weight that the commissioners think it deserves to be given. I think the point was that it's our understanding that Cub wanted the earning sharing mechanisms to be in alignment. And now what we have are two ESMs adopted, but that's just subtext, okay? So I think the way it's been presented, in the minimal way it's been presented, I think it's just worth noting, just more than anything, to keep the commission apprised of what's going on with, different agreements on these things.
Okay, well, yeah, I mean, I haven't had an objection to this, so I'll let it stay as it is, but I did note that, it does, I guess it's a little bit questionable, and it does raise some concerns for me, but parties don't have an issue with it, that's fine.
Judge, may I just respond briefly?
Oh, yeah, sure.
Yeah, like you said, we didn't object, and I don't object here, so I'm not asking for this to be stricken or anything, but I just, since we're on the record, I do want to emphasize that we, as a general matter, and specifically for the settlement that's referenced here, we don't think it's of any probative value for the reasons you alluded to, which is that, there's a host of compromises and negotiations that culminate in something. And so any particular term that a party agrees to or that Cub agrees to doesn't show our acceptance to that as a principle that we're going to accept or advocate for in another case.
Okay. All right, so we can move on. I think that's all the questions that I had. So there being no objections to surrebuttal, I can state for the record that I'll accept all the documents listed on the offered evidence list, subject to verification and the corrections that I've requested. So they're in the record, and you can just refer to them as being in the record. No need to offer them now. And I believe we can get started. So first thing we want to do is just we can excuse people who there's no questions for, and we can make sure we're taking people at the right time. It looks like we probably won't have any problems doing that. So let's just start with the applicant. Are there any witnesses that for which there's no cross that you'd like to have verified by affidavit?
Judge, applicants arranged for all of its witnesses to be present today, and we prefer to avoid the administrative headache of affidavits and just put them up and get them sworn and get their testimony in that way.
All right, sounds good to me. How about Cub?
Yeah, we'd like to take the same approach with our witnesses.
Okay. Just to note. Yep. Local 953. There's no objections to your testimony. You could file an affidavit verifying this, or we could just have you get on the stand and do that. It's up to you.
Perfectly comfortable with going on the stand, Your Honor.
Okay. Renew, same thing.
Yes, Your Honor.
Okay. Walmart.
We can verify on the stand as well, Your Honor.
I'm going to change things up then. We would like to submit an affidavit.
Okay.
Thank you.
And there's no cross, right, for sure. I didn't see anything there. Okay, how about commission staff?
All of staff witnesses will verify their testimony on the stand today.
Okay. All right. So in terms of cross, I think we have time. So I'm not going to have to change this so I don't get confused. Okay, so I think Kime is someone that's subject to cross. Is that the only witness?
That for the applicant, I think we indicated yesterday on our supplemental pre-hearing notifications that we may have some cross for him. I can say we do not plan to cross Dr. Kime on his written testimony, but only if anything is said in additional orally today. We reserve the right to cross-examine that. And the same with Mr. Belkkey, but other than that, we do not have cross-examination questions for any of the witnesses.
All right. Similar, how about other parties and staff? With the same constraints that Attorney Humayden has described, is there any cross planned at this time for other witnesses?
Judge, I had indicated by email that we might have testimony for Mr. Coyne from the applicant, but we've since decided that we likely do not have cross subject to the same condition, based on his oral testimony today.
Sure. Okay, appreciate that.
I'm sorry, what was the name of that witness?
Oh,
Mr. Coyne.
Thank you.
yeah. Anyone else? All right, well, let's get started then. That's so we'll see what the oral testimony brings, but hopefully won't be taking too much time here. All right, so let's have the applicant call their first witness. Go ahead.
If now, before I do that, Judge, I'll just let everyone know we're not going to be going in alphabetical order today, and we did disclose we might need to take a few after 11 o'clock.
Yes.
We won't have any additional direct testimony today. It'll all be responsive testimony to the written testimony that's filed, just to give people the atmosphere of what's happening here. So the first applicant's first witness is Ms. Mara Ashman.
Okay. There you go. All right. So I think I'll just leave you a little box. I can make you bigger for everyone, but I think it's because I want to be able to see the attorneys too in case there's an objection. So let me swear you in. Raise your right hand. You swear or affirm, tell the truth, the whole truth, nothing but the truth.
Yes, I do.
All right. Go ahead, Attorney Meiden.
Thank you, Judge. Please state your name for the record and spell your last name.
Good morning. My name is Mara Ashman. The spelling of my last name is Ascheman.
Thank you. Are you the same Mara Ashman that submitted direct rebuttal, surrebuttal written testimony, and exhibits marked EX-NSPW-Ashman 1 through 4?
Yes.
Now, were the answers you provided in that testimony and the information provided in your exhibits true and accurate to the best of your knowledge?
Yes, with the exception of one correction to my revised rebuttal testimony. On page 10, line 16, the reference to exhibit NSPW Ashman 1 should be a reference to exhibit NSPW Ashman 2.
Okay, thank you. Now, in your written surrebuttal testimony, you explained that you would address Cub witness Mr. Jeff Adams' amended proposal for additional reliability reporting at hearing. Have you now reviewed Mr. Adams' surrebuttal testimony?
Yes, I have.
And what is your response to Mr. Adams' amended proposal?
By way of background, in the direct testimony of staff witness Kevin Vesperman, he proposed a compliance obligation which requested, among other things, actual reliability data for the 15 feeders in Tier 2 areas according to the company's wildfire mitigation plan. Essentially, Mr. Adams also wants estimated SAIDI, which is spelled SAIDI, SAFI, which is spelled SAIFI, and CAIDI, which is spelled CAIDI, improvements for those 15 feeders, as well as any other lines scheduled for programmatic vegetation management. While Mr. Adams' recommendation continues to be disproportionate to the topic on which the idea of a compliance obligation was raised, in this particular circumstance, the company is willing to provide the information as part of the compliance obligation requested by Mr. Vesperman. With that, the company would propose that the following new subpart to the compliance obligation Mr. Vesperman proposed in his direct testimony, starting at page 11, line 12. Subpart H, the estimated SAIDI, SAFI, and CAIDI improvements for lines scheduled for vegetation management and tree trimming activity as part of the wildfire mitigation plan.
Thank you, Ms. Ashman. I have no further questions.
All right. Thanks for that. We'll just need to get the rebuttal refiled with the correction that you noted for the record. And so that'll be in three working days. So is there any cross-examination for this witness at this time? Not hearing any. Thanks very much. You're excused.
Thank you.
It's
Oh,
next
we're-
witness.
Okay,
Is
you were
Gene
muted
Coyne.
for a minute there.
Okay.
Yeah, just
Thank you. The applicant's next witness is its expert witness, Jim Coyne, and he's actually testifying remotely. He's not with us here today.
I see him there. All right. Let me swear you in. Raise your right hand. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
I do.
Okay, go ahead.
Good morning, sir. Can you please state your name for the record and spell your last name?
Good morning. It's James Coyne, and that's Coyne.
Thank you. Are you the same James Coyne that submitted direct, rebuttal, and surrebuttal written pre-filed testimony and exhibits NSPW marked exhibit NSPW Coyne 1 through 4?
Yes.
Now, were the answers you provided in your written testimony and information provided in your exhibits true and accurate to the best of your knowledge?
Yes.
And are the opinions and conclusions presented in that testimony made to a reasonable degree of certainty in your profession?
Yes, they were.
Thank you. Have you had the opportunity to review the written surrebuttal testimony of Cub witness Dr. Coyne?
I have.
And do you have any responses to that testimony that you'd like on the record?
Yes. I'd like to address two primary points raised by Dr. Coyne in his rebuttal testimony.
Okay. Why don't you begin with any response you have to Dr. Coyne's criticism of your use of a constant growth rate form of the DCF model and estimating the forward market return in the CAPM model?
Sure. Dr. Coyne spends 7 pages of his 13-page rebuttal redoubling his criticism of my use of a constant growth rate form of the DCF model and estimating the forward market return in the CAPM model. In doing so, he goes as far as asserting not only am I wrong in doing so, but I am axiomatically wrong based on financial theory, and I am imprudent in doing so. In rendering these judgments, Dr. Coyne either ignores or fails to consider 3 fundamental points. First, the forward-looking estimate of the market return I have estimated are based on the methodology employed by FERC after 2 decades of litigation and expert opinions. By extension, I wonder if Dr. Coyne is characterizing the Federal Energy Regulatory Commission as wrong or imprudent. Secondly, the market return we are estimating is that for the Standard & Poor's 500 or the S&P 500, which we both, that is me and Dr. Coyne, use as a proxy for the overall market return. The fact is that the S&P 500 market return over the past 75 years has averaged 10.8% annual growth. In comparison to nominal GDP, which averaged 6.3% over the 1950 to 2024 period. So clearly, the S&P 500 can and does grow faster than GDP, actually 71% faster over the past 3/4 of a century. That's just a fact and not a theory. Thirdly, I have, and perhaps most importantly, I have presented 8 alternative ROE model results in both my direct and surrebuttal testimonies. If I were to concede Dr. Coyne's position on the validity of the forward market return, which I do not, and use only the actual market return over the past century, as I do in 2 of the 4 CAPM models presented in my evidence, the average results of all models would be 10.56% in my direct and 10.23% in my updated rebuttal analysis, both of which exceed the company's requested 10% ROE. In short, Dr. Keim's critique is unfounded and without any real bearing on my overall analysis and the company's requested ROE, which my analysis, with or without the forward market return, supports as reasonable and fair for the company's customers and shareholders.
Thank you, Mr. Coyne. Now, Dr. Keim in his rebuttal testimony goes on to suggest that the commission ought to accept a decline in the share price of NSPW's parent company, Xcel Energy, as an acceptable, if not desirable, outcome as a result of Dr. Keim's ROE recommendation. Are you familiar with that testimony?
Yes, I am.
Do you have a response to that testimony?
I do, and I wonder if it would be possible to bring up, I didn't create any exhibits for my oral rebuttal, but I'm wondering if it would be possible to bring up page 10 of Dr. Keim's rebuttal testimony so I could refer to that chart.
Yes, of course. I was trying to look for that. Exactly. Thanks for giving me the citation there. So it's the Pinnacle West table?
Yes.
Perfect. Okay, great.
Exactly. Yeah.
Go ahead.
Perfect. Thank you. Dr. Keim goes on to suggest that the commission should accept a decline in the share price of NSPW's parent company as an acceptable, if not desirable, outcome as a result of his ROE recommendation. This seems somewhat at odds with his direct testimony where he states, and I quote, "The key to recognize that impact of changing the ROE lands on existing investors whose interests, while not controlling, are relevant." End of quote. Nonetheless, in his rebuttal, he cites the example of Arizona Public Service as support for this premise. But in doing so, he paints a misleading and incomplete picture of the facts surrounding APS. Dr. Keim first correctly reports that the Arizona Corporation Commission lowered the ROE of APS from 10% to 8.7% in 2021. He then goes on to assert that the company raised hundreds of millions of dollars of more capital at the lower ROE, citing investment by the parent company through 2025 in the chart that we're looking at here in his rebuttal testimony. So in essence, he's saying that the commission lowered the ROE to 8.7%. The company had no trouble raising the capital it required, and the parent company went on to invest, as illustrated in this chart, with this 8.7% ROE. That's how I read his testimony, which was a, quote, win for consumers at the expense of existing investors. But the complete set of facts paint a very different picture. What he fails to report is APS sued the commission after regulators in 2021 denied recovery for its investments in the New Mexico plant and reduced its return on equity, citing customer service issues in doing so. The Arizona Court of Appeals ruled in the utility's favor and remanded that case back to the ACC. Following the remand in 2023, the company settled for an 8.9% ROE, 20 basis points higher than the commission allowed in its 2021 decision. The ACC had set the ROE at 8.7%, citing deficiencies in APS's customer service performance. But the court ruled that concern was, quote, beyond the commission's rate-making authority. Then, in February of 2024, APS received ACC approval for a rate increase of $492 million based on an effective ROE of 9.85%. And the commission is currently before the company is currently before the commission with a requested 10.7%. But despite these improvements, APS's credit rating was downgraded in 2021 by all three credit rating agencies and has not since recovered. The actual downgrades were from S&P, who lowered its issuer rating from A- to BBB+. Moody's downgraded APS's issuer rating from A2 to A3. and the rating of Pinnacle West from A3 to Baa1. And Fitch downgraded APS's rating from A- to triple B+.
Are you saying triple B or D?
A triple B. Yeah, sorry.
B is in
B like
Bob.
boy.
B
Thank
as
you.
in boy, yes. Yeah, thank you. Furthermore, Arizona's Standard & Poor's global regulatory ranking declined from average 3 all the way down to below average 3 in 2021. That's a full 3 notches before recovering modestly to below average 2 in 2024. Only 2 other commissions in the country are ranked at this level or lower. So the reversal of the Arizona Commission's decision has been complete, but the customers will be paying more for capital with a reduced credit rating at a time when that company, like NSPW, is making significant investments in its infrastructure. It's hard in my mind to reconcile these facts with Dr. Keim's partial picture and a characterization as a win for consumers in Arizona, or a model to be emulated in Wisconsin, which has a constructive regulatory ranking of above average 3 from S&P, and one of the few commissions that enjoy that ranking. These conclude my comments on Dr. Keim's rebuttal.
Thank you, Judge. I have no further questions for Mr. Coyne.
All right. So do we have any cross based on that statement or those statements?
Judge, may we just have a few minutes to confer here?
Sure, I can we can go into recess for 5 minutes. I don't know how else you're going to confer unless are you in the same place?
That would be sufficient.
Okay, so we'll be off the record for 5 minutes.
Thank you.
Hey, everybody. Hey, nice job. Looking good. Thank you. I'm back. And ready, right? Ready. Do you want to go next? We'll just keep. No, I can go in the order.
Okay, time's pretty much up here. So did we have questions from Cub?
Judge, before Cub appears, I want to just do a sound check. You can hear me okay?
Yes.
Okay, we had to reconfigure some things, so just didn't want that.
And I see Todd Weiner is I don't know if that's a connection in the room there, but I'll let him in. Okay. Yeah, so Attorney Narby, any questions?
Yes, I do have a few questions for Mr. Coyne. Thank you.
Okay, yeah, go ahead. Introduce yourself to the witness and go ahead.
Yes, Mr. Coyne, my name is Daniel Marvey. I'm an attorney for the Citizens Utility Board, and I have a couple questions for you based on your testimony just now. I'd like to start with the first part of your testimony when you were talking about the growth rates in your models. You testified that the growth of the S&P 500 exceeded the average growth of GDP for the past 75 years. Is that your testimony?
Yes, it is.
When you are referring to the S&P 500, you're talking about the total return on index, aren't you? Not the earnings per share?
That's right. The total return to the market.
And now I'd like to turn to the Arizona Public Service decisions. You went into some detail about the procedural history of that case. Is it correct, Mr. Coyne, that the initial decision was to reduce the ROE from 10.0 to 8.7, correct?
That's correct.
And then, as you noted, the Court of Appeals reversed, at least in part, that decision?
That's correct.
And following that reversal, the ROE was revised upward to 8.9. Is that accurate?
That's correct.
Now, you testified about some consequences that arose from that decision by way of credit ratings and I forget how you phrased it, but essentially the regulatory rating of the commission itself. Is that right?
Yes.
Is it nonetheless still accurate that the company has still been able to raise capital since those events took place?
It has. As I mentioned, there was a subsequent rate case where the company received a 9.85% ROE, which brought it back up more or less to the national average. But even with that, the company remains downgraded by all three major credit rating agencies. So all else being equal, a downgraded company pays more for its debt capital, the one that had retained the prior credit rating. And it is accessing capital, but it's paying more for that capital. And that's my point. And that's counter to the position that I understand Dr. Keim has taken in his rebuttal, indicating that this was somehow a benefit for consumers.
Now, you just testified that as a result of the ratings downgrade, the company was paying more for its debt capital, correct?
That's correct.
Do you know, as you sit here today, if they are paying more on a weighted average cost of capital basis?
I have not measured whether or not they're paying more on a weighted average cost of capital basis.
You testified that in a subsequent rate case, the ROE was moved up to 9.85. Is that right?
Yes. That's the effective rate because it includes both a base rate and an increment in Arizona called the fair value increment.
And do you know if those rates have taken effect yet?
The decision was rendered in February of 2024. I do not know when those rates took effect.
Do you know if they have yet taken effect?
I do not.
Thank you, Mr. Coyne. No further questions for the witness.
Okay, any other party has cross for this witness? No? Commission staff? No? All right, any redirect?
No redirect.
All right, thank you. All right, thank you, witness Coyne. You're excused.
You're welcome.
Let's take our next witness.
Okay. We have to do a little switcheroo here because Mr. Shea's going to take some witnesses. So give us just a moment to do that.
Sure, no worries. Off the record.
Yeah.
Back on the record, Your Honor.
Okay, go ahead, Attorney Shea.
NSPW's next witness will be Mr. John Goodenough. And he's appearing, I believe, remotely.
Yep, I see you there. So I'll swear you in now. Raise your right hand. Swear or affirm, tell the truth, the whole truth, nothing but the truth.
I do.
Okay, go ahead.
Please state your name for the record and spell your last name.
My name is John Goodenough, Goodenoughg.
And are you the same John Goodenough who submitted pre-filed direct testimony and exhibits titled EX NSPW Goodenough 1C and also EX NSPW Goodenough 1P?
I am.
And were the answers you provided in that testimony and was the information you provided in your exhibits accurate to the best of your knowledge?
Yes.
Thank you, Mr. Goodenough. No further questions.
Okay, and I don't believe there's any cross for this witness. Last chance for questions. All right, thanks very much. You're excused.
Okay, I think we're gonna go off the record for just a minute and switch back to Jordan.
Okay, all right, off the record.
We're getting good at this, Judge.
Right.
I think so anyway. I think NSPW's next witness will be Mr. Todd Warner, and I believe, can you see him?
I believe I've let him in. I don't see him yet. Oh, there we go. Perfect. All right, just need to unmute. All right, I'll swear you in. Raise your right hand. Do you swear or affirm to tell the truth, the whole truth, nothing but the truth?
I do.
Okay, great. Go ahead.
Good morning, sir. Please state your name for the record and spell your last name.
It's Todd Wayner. W is in whiskey, E is in echo, H is in Henry, N is in November, E is in echo, R is in Romeo.
Thank you. Are you the same Mr. Wayner that filed written direct and rebuttal testimony together with exhibits marked EX NSPW Wayner 1 through 8?
I am.
Now, were the answers you provided in that testimony and the information provided in your exhibits true and accurate to the best of your knowledge?
They were and are.
Thank you. Thank you. Those are all the questions I have.
Okay, is the witness available for cross? Any questions for this witness? No? All right, thanks, you're excused.
Thank you.
Okay.
NSPW's next witness is Mr. Dante Catanzaro.
Okay. Okay, see a witness there. Let me swear you in. Raise your right hand. Do you swear or affirm to tell the truth, the whole truth, nothing but the truth?
I do.
Okay, go ahead.
Please state your name for the record and spell your last name.
Dante Katanzaro, Catanzaro.
And are you the same Dante Catanzaro who submitted pre-filed direct and rebuttal testimony in this matter, along with exhibits titled EX-NSPW-Catanzaro 1C and 1P?
I am.
And were the answers you provided in that testimony and the information you provided in your exhibits accurate to the best of your knowledge?
Yes.
Thank you. No further questions.
All right, any questions for the witness? No? All right, thanks very much. You're excused.
Thank you.
Next witness?
NSPW's next witness is Mr. James Aurand.
All right. See you there. Raise your right hand. Do you swear or affirm to tell the truth, the whole truth, nothing but the truth?
I do.
Okay, go ahead.
Please state your name for the record and spell your last name.
My name is James Aurand. My last name is spelled A-U-R-A-N-D.
And are you the same James Aurand that submitted pre-filed direct testimony in this matter, along with an exhibit titled EX-NSPW-Aurand-1?
I am.
And were the answers you provided in that testimony and was the information you provided in your exhibit true and accurate to the best of your knowledge?
Yes.
Thank you. No further questions.
All right, any cross-examination for this witness? No, thanks, you're excused.
Thank you.
NSPW's next witness is Nick Schuster.
All right, see you there. Raise your right hand. Do you swear or affirm tell the truth, the whole truth, nothing but the truth?
Yes.
Okay, go ahead.
Please state your name for the record and spell your last name.
Nick Schuster, S-C-H-U-S-T-E-R.
And are you the same Nick Schuster who provided pre-filed direct and rebuttal testimony in this matter, along with an exhibit titled EX-NSPW-Schuster-1R?
Yes.
And were the answers you provided in that testimony and the information provided in your exhibits true and accurate to the best of your knowledge?
Yes.
Thank you. No further questions.
Any questions for the witness? No? All right, thanks very much. You're excused.
We're going to take a few minutes to do some switching again. Our next witness is going to be Ms. Julie McCrae. Just give us one moment.
All right, thanks for that. We'll go off the record. Ready to go?
Yep.
Yes.
Okay. All right, let's get back on the record. Raise your right hand. Do you swear or affirm, tell the truth, the whole truth, nothing but the truth?
I do.
All right, go ahead.
Good morning. Please state your name for the record and spell your last name.
Julie McCrae, spelled MCREA.
Thank you. Are you the same Julie McCrae who submitted written direct and rebuttal testimony in this proceeding together with exhibits marked EX NSPW McCrae 1?
Yes.
And were the answers you provided in your testimony and the information provided in your exhibits true and accurate to the best of your knowledge?
Yes, they were.
I have no further questions.
All right, any cross for this witness? Nothing. All right, thanks, you're excused.
Oh, Jordan.
Oh, I'm sorry.
Oh,
Jordan
sorry.
had questions.
I do have questions.
Sorry.
I was jumping the gun there. Now,
I'm sorry,
Now-
who's speaking?
I think that
I'm
was
Said I do have questions.
Oh, this is Jordan Hamid.
Jordan Hamid, I do have further questions. for
Oh,
her.
I'm sorry. I thought it was somebody else.
I didn't have any more preliminary ones, but I have others.
Okay, go ahead.
Now, Ms. McCrae, have you reviewed PSCW staff witness Mr. Griffin's testimony?
Yes, I have.
And that portion that proposes to refund the 0.2 million on the Cedar Falls project that was recovered from customers in 2023?
Yes.
Could you please state your thoughts on Mr. Griffin's proposal?
Mr. Griffin's testimony addressed the Cedar Falls project delay in two ways. First, with the staff's proposed plant and service adjustment, and secondly, with this proposed refund. If the commission decides to refund the $0.2 million to customers, this would be penalizing the company twice on the Cedar Falls delay. It is the company's position that if the commission refunds the $0.2 million, then they also need to adopt the company's proposed revision to the plant and service adjustment in order not to double penalize the company.
Mr. Griffin also filed surrebuttal testimony associated with the union headcount. Have you reviewed that portion of Mr. Griffin's surrebuttal testimony?
Yes, I did.
Now, in that section, Mr. Griffin noted it may be reasonable to add back the 7 actual union headcount positions noted in your rebuttal testimony. What is your response to that?
While Mr. Griffin has noted it would be reasonable to add back the 7 union positions that have been filled since May of 2025, these 7 headcount do not account for continued union headcount growth. As noted in my rebuttal testimony and Mr. Weber's surrebuttal testimony, this growth is necessary to support utility operations and to serve our customers. The company is still requesting approval of the union headcount as proposed in our initial filing. This would be an add back of 10 headcount instead of the 7 to staff's adjusted position.
Now, have you had an opportunity to address PSCW staff witness Mr. Milada's notation of a MISO error associated with capacity sales revenues for 2025 and 2026, which affects the 2026 fuel cost plan?
Yes, I'm aware of the error.
Now, do you agree with the manner in which Mr. Milada presents or proposes addressing the error?
Partially. While I agree with Mr. Milada is correcting the error and applying the price reductions to the 26 fuel cost plan, I still disagree with staff's proposed methodology in establishing the average of the 2 seasons prices.
Why do you disagree with staff's proposed methodology, and what are your recommendations?
As mentioned in my rebuttal testimony, the 2-year average pricing Mr. Milada is using results in a price increase between the 2 summer seasons that is more than 20 times higher than the lower summer season price. Given this volatility, I am still concerned the price forecast proposed by staff overrepresents actual revenues. Additionally, given the recent errors found by MISO, along with the speculation and risks associated with the capacity auction results, I still believe it is reasonable to adjust or to reduce staff's revised proposed adjustment of approximately $4.1 million by 50% to approximately $2 million.
Now, Mr. Milada addressed in his surrebuttal testimony the escrow accounting treatment for capacity sales revenue and capacity purchases. Do you have anything you would like to add regarding this issue?
Yes, I brought up this issue in my rebuttal testimony, suggesting that parties could explore in the future how fuel rules and escrow accounting addresses both capacity sales revenue and capacity purchases. I am aware that moving capacity revenues out of fuel rules or capacity purchases into fuel rules would require a legislative change to the administrative code, which the company is not requesting to do in this proceeding. Additionally, the company is not requesting escrow accounting treatment of either capacity revenues or purchases in this proceeding. Instead, I was simply suggesting that stakeholders work in between rate cases to find a better recovery solution.
I have no further questions for this witness.
All right, for real. Let's have any cross.
For real.
Any interveners with cross? Commission staff? No? All right, thanks very much. You're excused.
Thank you.
Who's next?
Okay, the applicant's next witness is Mr. Terrell Zeke.
All right, raise your right hand. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
I do.
Okay, go ahead.
Please state your name for the record and spell your last name.
My name is Terrell Zeke, Z-I-C-H.
Are you the same Terrell Zeke who submitted written, direct, rebuttal, and surrebuttal testimony and exhibits which have been marked EX-NSPW-Zeke-1 through 3?
Yes.
Now, were the answers you provided in that testimony and the information provided in those exhibits accurate to the best of your knowledge?
Yes.
Have you had an opportunity to review the surrebuttal testimony of Cub witness Mr. Adams regarding a potential demand response study and the surrebuttal of staff witness Keano and Renew witness Belkkey?
Yes, I have verbal testimony to offer in response to surrebuttal from the Cub witness, staff witness, and the Renew witness.
Okay. Now, have you read Ms. Keano's surrebuttal testimony on the company's proposed RAAP, and could you tell me what RAAP stands for?
Yeah, yes, I have, and that stands for the Residential Arrearage Assistance Program.
Now, in her testimony, Ms. Keano proposes to modify the RAAP tariffs to include the 10% reduced down payment detail. Do you agree with the tariff language proposed by Ms. Keano?
I do, and we greatly appreciate the collaboration on this topic throughout the proceeding.
Okay. Now, did you read Cub witness Mr. Adams' surrebuttal testimony on demand response and the requirement to have a demand response potential study with NSP Wisconsin specific information?
I have, yes.
Do you have any response to the facts stated in Mr. Adams' testimony?
Yes, page 2, line 3 of Mr. Adams's surrebuttal states that the next IRP would be filed in Michigan would include a DR potential study. While this is true, I'd just like to clarify that the IRP filing originates in Minnesota, and after the MPUC approval, the Minnesota IRP is filed in Michigan to comply with IRP requirements there. But the next IRP filing begins in Minnesota.
Now, do you support Mr. Adams' recommendation to require Wisconsin-specific information in the planned demand response potential study?
I appreciate Cub and Mr. Adams' collaboration on this topic.
I'm sorry, you appreciate Cub and Mr.
Adams's collaboration on this topic throughout this proceeding. While I support Mr. Adams's potential proposal in concept, including Wisconsin-specific information comes with incremental cost to NSPW. This issue impacts the company's revenue requirement, but was raised after the finalization of the audit by commission staff. If the company is being asked to take on additional costs after the staff audit was completed, those costs should be included in the revenue requirement or otherwise addressed. The scope of the load flexibility study is underway and being prepared in support of the upcoming integrated resource plan and considers the entire NSP system and will not contain Wisconsin-specific information as currently scoped. The company can support Mr. Adams's recommendation with the inclusion of an estimated $200,000 in O&M expense to this rate case to fund the expanded study. Alternatively, the company would support maintaining the study in its current form as not including Wisconsin-specific information and providing Wisconsin-specific information in the next load flexibility study that's prepared.
Now, there's $200,000 that you just testified about that should be included in the O&M expense if the study's expanded. Why is that $200,000 needed?
$200,000 would allow Xcel Energy to modify the scope of the NSP system load flexibility study to allow statistically significant conclusions to be drawn about Wisconsin separate from the NSP system as a whole. The current study includes a sample of NSPW customers as part of a broader sampling of the entire NSP system customers. And that sample is designed to achieve statistically significant conclusions about the entire NSP system. According to the company's experience in past studies, approximately $125,000 of the additional funding would be used for modeling, project management, and reporting, and the estimated remainder of $75,000 would be used for customer research. The current study would likely capture a few dozen Wisconsin customers on the way to achieving a total of hundreds of completed responses across the NSP system. Given similar studies we have conducted in other states, I would expect the incremental $200,000 would get us a much more robust mix of customer data specific to Wisconsin. For reference, a 2021 study in New Mexico that the company completed acquired a few hundred additional, up to 300 additional residential customers and business customers that would be possible to achieve in Wisconsin, along with an accompanying more granular analysis specific to the state of Wisconsin.
Now, without this additional funding, would the company be able to draw conclusions about Wisconsin separate from the NSP system?
Not in a statistically significant manner. However, as the study is currently scoped, the study would give us a qualitative or directional findings about where Wisconsin customers seem to be aligned with the larger NSP system. Doing the state-specific work would be getting something that quantitatively provides confidence in program design specific to Wisconsin customers.
Now, Mr. Zeke, when it comes to the system-wide, NSP system-wide load flexibility study, what do you believe the commission's options are from your perspective?
Sure. First, they could continue with the currently scoped NSP system-wide load flexibility study without Wisconsin-specific information and require NSPW to file that finished study when completed. The commission could also order a subsequent study to be prepared that has Wisconsin-specific information and address funding in a subsequent rate case. So in the next IRP filing, the following IRP filing following this next one, we could have a load flexibility study specific to Wisconsin. Alternatively, the commission could direct NSPW to include Wisconsin-specific information in the currently scoped load flexibility study as recommended by Cub witness Mr. Adams, and add $200,000 of O&M to this rate case proceeding.
Okay, now I'd like to move on to your review of Cub witness Mr. Belkkey's rebuttal testimony. Have you reviewed that?
Yes, I've reviewed Renew witness Mr. Belkkey.
I'm sorry, Renew witness, I misspoke.
Yes,
Yep.
I have.
Okay, and do you have any general responses to Mr. Belkkey's rebuttal testimony?
Yes, NSPW collaborated with stakeholders, including Renew, leading up to the rate case filing, and held regular meetings with Renew and stakeholders throughout the rate case proceeding. Some of the issues raised by Mr. Belkkey are material policy matters that were not raised by parties in discussions prior to or during the rate case proceeding, and were raised late in this proceeding, as late as rebuttal. This approach is not generally conducive to good policymaking and risks unintended consequences. Further, some of the issues impact the company's revenue requirement, but were raised after the finalization of the commission staff revenue requirement.
Did you review Mr. Belkkey's rebuttal testimony on electric vehicles?
Yes, I did.
Do you agree with his new recommendations and compromise approach on that subject?
I always support additional stakeholder engagement. However, engagement needs to be completed on an appropriate timeline as data and resources are available to reach conclusions that benefit customers. Mr. Belkkey's recommendations seek to force collaboration on a premature timeline.
What is your response to Mr. Belkkey's first recommendation to allow the closure of NSPW's residential EV program with the condition that the company continue its EV advisory role as described in the direct testimony?
An order point requiring the company to maintain advisory services is not needed. I have already committed to continuing residential and commercial advisory services in my direct testimony, and the funding to do so is included in the revenue requirement. You can see reference direct NSPW Zeke line 20, page 20 at line 16.
What is your response to Mr. Belkkey's second recommendation, which is to order NSPW to conduct its EV advisory role in collaboration with Renew and stakeholders over the next year, including evaluating time of use rates and considering additional outreach or adjustments?
I posed an order point requiring collaboration between Renew and stakeholders over the next year. However, I can support an order point requiring collaboration between 2027 and 2029. I already committed to working with Renew and other stakeholders as the company develops future time of day rates for all end use types after the completion of AMI deployment and meter data availability, both in my rebuttal and surrebuttal testimony. As stated, the company is opposed to time of day modifications before AMI data is available and a thorough analysis can be completed. Exhibit Zeke 2, page 8, provides a timeline for this work and already includes in that timeline stakeholder engagement beginning in late 2027 and persisting through 2029.
Now, Mr. Belkkey makes a third recommendation, which is to require NSPW to file a TE docket to address these issues within 1 year. What is your response to that recommendation?
I am similarly opposed for the same reasons as my prior response. Company has already outlined a timeline to consider time of use rate changes following AMI deployment.
Moving on now to Mr. Belkkey's surrebuttal testimony on establishing a distribution hosting capacity map. Have you reviewed that portion of Mr. Belkkey's testimony?
Yes.
Now, do you agree the commission should order NSPW to adopt a hosting capacity map in this proceeding?
No, there is not enough evidence, nor is the cost to establish such a map part of the proceeding. If the commission desires to establish a hosting capacity map, a rulemaking should be initiated to ensure a consistent statewide model and to ensure all utilities and stakeholders have an opportunity to participate.
Do you have any response to Mr. Belkkey's conclusions that a rulemaking is not actually required and that NSPW can simply adopt a hosting capacity map because Northern States Power Company Minnesota already has a similar map?
I do. Mr. Belkkey does not recognize that NSP Wisconsin and NSP Minnesota are different utilities, subject to different laws, rules, and commission orders. For example, in Minnesota, the hosting capacity map was established by state legislation passed in 2015 that was later expanded on by commission order. No such enabling law or rule exists in Wisconsin, and this issue was also discussed during the PSC 119 rulemaking process that established the current interconnection rules in Wisconsin and was ultimately excluded from the final rule.
Are you aware of the Minnesota statutory provision, Mr. Zeke, that addresses the hosting map for that jurisdiction?
Yeah, the enabling legislation was established in Minnesota Statute 216B.2425, and that's sub 8 within that statute.
Continuing on with this hosting map issue, how do you respond to Mr. Belkkey's claim that NSPM's hosting capacity map demonstrates that implementing a map can be done without compromising privacy or security?
Mr. Belkkey does not recognize that the substantial security and privacy work that went into establishing the Minnesota hosting capacity map work that is ongoing. This includes the NARUC and ARUC grid data sharing framework funded by the Department of Energy, which is currently being adopted by Minnesota, resulting from a February 7th, 2025 commission order in docket number 20-800.
And that's a Minnesota docket number?
That is correct.
How do you respond to Mr. Belkkey's claim that NSPM's hosting capacity map demonstrates that implementing a map can be done cost effectively?
Mr. Belkkey presents no evidence to substantiate these claims. As I've stated, implementing a map is not costless and no costs are included in the company's revenue requirement to implement such a map.
And by company's revenue requirement, you mean NSPW's?
That's correct.
Revenue requirement.
That's correct.
Those are all the questions I have for this witness this time.
All right. Any cross from interveners?
I do have a
Can
couple
I?
of questions.
Oh,
Let's
go ahead.
take Cub first. We'll just go in alpha order. So go ahead, Attorney Narv.
Thank you. And thank you, Mr. Zeke. I introduced myself earlier, but I'm Daniel Narvey, an attorney for Cub. And I just have a couple of questions in relation to the potential demand response study. You said that the cost estimate of $200,000 for Wisconsin specific information was based at least in part on past studies. Can you provide a little bit more explanation on how past studies support the cost estimate of $200,000?
Yeah, we had a few days here to look at how much it would cost to implement such a study in Wisconsin with specific information covering Wisconsin customers, and we relied on studies from other states. We've included Wisconsin or specific information about that state in the study, and that's what we use to derive the $200,000 estimate. It is an estimate. I'll reiterate, we had only a few days to figure out how much it would cost, but we have done multiple studies before with specific information about specific states.
And are those costs for generally additional employee time, contracting, or something else?
Yeah, it's stated in my verbal testimony today. The additional funding would be used for modeling, project management, and reporting, and also customer research.
Thank you. Last question. You testified about you proposed a second alternative for the commission to consider, under which the Wisconsin specific information would be filed not with the next IRP filing, but in 2027, but with the subsequent filing after that. Was that your proposal essentially?
That's correct.
When would that next IRP filing be made after the one after the 2027 filing?
I don't have that information generally, subject to regulatory decisions in other jurisdictions that have IRPs. We file IRPs in Minnesota generally every 3 years.
Okay, so the understanding you can't predict the future, but the best information you have, it would probably be in 2030. Is that fair?
That's reasonable, yes.
Okay, thank you. No further questions.
Okay, next intervener, Renew, did you have questions?
Never mind, Your Honor. I just needed a moment to confer, but we have no questions.
Okay. Any other interveners with questions for the witness? No? Okay. How about commission staff?
No, Your Honor.
Okay. So I did have a couple of clarifying questions for you, witness Zeke. Just I think it's based on this demand response study. I guess just wanted to make sure I understood that there's no Wisconsin customers included in the current study that's being prepared for the Michigan IRP.
There are currently Wisconsin customers included in the NSP-wide system load flexibility study being prepared for the Minnesota IRP. However, that amount of customers isn't significant enough to draw statistically significant conclusions about Wisconsin.
Okay, got it. And then Michigan, so the way what I hear you saying, confirm this for me or set me straight here, but it seems like Michigan uses a total system demand response study to for its use in determining the IRP for the NSPM criteria that it uses for that utility. To what extent can Wisconsin use the total system IRP for the same purpose?
Yeah, generally Michigan has separate IRP requirements that that are required for their IRP process. However, they allow us to file the Minnesota IRP as a multi-state utility instead of those requirements. In that sense, the Minnesota IRP includes a potential study. Therefore, our Michigan IRP includes a potential study. To answer your question, as I testified to today, we can draw qualitative conclusions about Wisconsin from the NSP system-wide potential study because it does include a sample of customers. Just, again, that sample isn't statistically significant to draw robust conclusions about Wisconsin. However, qualitatively and directionally, we could draw some conclusions.
But how does the Michigan Commission use the demand response study? Is there more information that it can use compared to the Wisconsin information, or is it just you take that as a qualitative analysis?
Yeah, with Michigan, the best of my knowledge, doesn't require a demand response potential study to be completed. We simply include it as part of the IRP because we copy paste the IRP from Minnesota into Michigan to meet Michigan's IRP requirements. Again, we have about 9,000 customers in the Upper Peninsula of Michigan. The commission lets us, use a multi-state IRP to meet the compliance in Michigan.
Right, and how about with Minnesota though? Is it using the demand response study in a different way than Wisconsin would be using it at this point?
No.
And then to what extent is that useful? I mean, what does Minnesota do with the study that we couldn't do with the study as it would be filed currently?
I don't think I know the answer to that question. I can say that Minnesota is about 84% of the load of the NSP system. So it does make up a larger portion, and therefore a larger portion of the sample of customers will be from Minnesota. But I can't speak to how it's used in Minnesota.
Okay. But so that Minnesota hasn't directed the company to do something at this point with that information in past years.
I can't speak to what the Minnesota Commission has ordered, other than they do require the inclusion of a demand response potential study to be completed as part of the IRP filing.
Okay. And would you consider that the Minnesota information to be statistically significant in that study?
I don't know the answer to that, but I suspect it would be, given the sample size, relative share of the system over there, but I don't know for sure.
Okay, that's fine. All right. Okay, so and then just in terms of your estimate, the 200,000 for the Wisconsin study, you don't have like an exhibit or a proposal. What am I trying to say? You don't have like an invoice that would be something you could file in this case saying this is the cost. It's just your back of the envelope estimate. Is that correct?
Yeah, that's correct. Based on our experience and the number of customers that we would need to sample in Wisconsin, in our experience in other jurisdictions, it's not currently part of the current scope of the load flexibility study. Therefore, we don't have contracts or invoices to justify that estimate specifically.
And if the Wisconsin Commission would be to order that Wisconsin specific demand response study be done? Could it be done in a different timeline than the ones that are more than the total system study?
Yes, it could. It may involve additional cost than the $200,000.
Okay, that's fine. All right, great, thanks. All right, so any redirect?
No redirect.
Okay, thanks very much, and take care. Thanks very much. Wait a sec. All right, who's left for the
Okay. Before we put up our next witness, there were some questions that Mr. Narvi asked of our previous witness, expert witness, Mr. Coyne, that he didn't know the answer to offhand, but we have that fact now. And it was specifically about when the rates went into effect with respect to that Arizona Public Service rate order. So if I could be if I could, I'd like to just put Mr. Coyne back on the stand for 30 seconds so we could answer that question on reader.
Yeah, I don't know if that's super important. Did you would that be useful, Attorney Narvi, to have that question answered more fully?
If it's just the question and answer that he described, we don't have an objection to it. I don't know if it's useful or not.
Okay, I mean,
I'm fine with it.
If it's just to the extent the rates go into effect, yeah, we can take that just to button it down. So why don't we call or recall witness Coyne?
Okay. Coyne, are you with us? Ready to go?
Yes. Yes.
All right.
Okay.
Thank you.
So let me remind you, witness Coyne, you're under oath.
Understood.
Understand that?
Understood.
Okay,
Thank you.
Okay, thank you. Mr. Coyne, welcome back. I'm simply asking, when you were cross-examined by Mr. Narvi about the Arizona Public Service rate order, to some extent, he had asked whether you knew when those rates became effective for the rate order that raised the ROE back up to the 9.8%, I believe it was, level.
Yes.
And do you have that information?
I do. Yeah, I've subsequently checked the Pinnacle West Form 10K, and it says, and I quote, "The ACC issued the final order for the 2022 rate case on March 5th, 2024, with the new rates becoming effective for all service rendered on or after March 8th, 2024.
Thank you. I have no further redirect.
All right, great, thanks. So we can excuse you now, witness Coyne, and we'll take the next witness.
Thank you.
The applicant's next witness is Mr. Ryan Moldenhauer.
Okay, I see you there. Raise your right hand. Do you swear or affirm to tell the truth, the whole truth, nothing but the truth?
I do.
All right, great, go ahead.
Please state your name for the record and spell your last name.
Ryan Moldenhauer, Moldenhauer.
Are you the same Ryan Moldenhauer that provided written direct testimony, rebuttal testimony, and exhibits that have been marked EX:-NSPW-Moldenhauer-1 through 7?
Yes.
Were the answers you provided in that testimony and the information provided in your exhibits accurate to the best of your knowledge?
Yes.
Have you had an opportunity to read Mr. Fischer's rebuttal testimony on NSF charges?
I did.
And are Mr. Fischer's recommendations for NSF charges reasonable in your estimation?
Yes. Mr. Fischer provides two methods for NSF charges, an average cost method at $6.86 and a high-cost method at $7.48. I believe the range of these values to be reasonable, though for simplicity and clarity to customers, I would suggest the final NSF charges be rounded to the nearest whole dollar. An NSF charge of $7 would seem reasonable.
Thank you. I have no further questions.
Okay, any cross? Not hearing any. Thanks very much. You're excused.
We will need a moment for our final witness.
All right, go off the record.
Applicant's next witness is Ms. Ashley Adams.
All right, let's get on the record. I see you there. Raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Okay, go ahead.
Please state your name for the record and spell your last name.
Ashley Adams, last name spelled A-D-A-M-S.
Are you the same Ashley Adams who submitted written, direct, and rebuttal testimony together with exhibits marked EX:-NSPW-Adams 1 through 5?
Yes.
Were the answers you provided in that testimony and the information provided in your exhibits accurate to the best of your knowledge?
Yes.
Now, have you read PSC staff witness Ms. Swatulski's rebuttal testimony regarding the company's proposed remote metering tariff?
Yes.
Do you support Ms. Swatulski's recommendation to add clarifying language to the gas rules and regulations specific to the proposed remote metering charge?
Yes.
Now, would you like to submit any exhibits with your testimony today which reflects that clarifying language proposed by staff?
Yes. Exhibit NSPW Adams 6 contains updated tariff sheet number 53.1, reflecting the clarifying language proposed by staff.
Okay. Now, Judge, we prepared that exhibit and circulated it to the service list, and I believe to you as well. So we would like to introduce that based on that foundation into the record.
Yes, and I can display that on the screen. Yes, that was properly shared with parties and commission staff. So to the extent we're requesting, applicants requesting that I receive this exhibit now, are there any objections? No? Okay, so I can receive that along with all the other documents on the offered evidence list. So thanks for bringing that up.
Judge, should we also file this?
Yes, it'll be filed on IRF now under the existing exhibit marking that you have.
Okay, we can do that within the 3 days.
Absolutely.
With the others. Okay.
Yes.
All right. We are finished presenting our witnesses.
Okay. Well, are there any questions for witness Adams? No? Okay, great. So you're excused. Thanks very much. And that's the balance of the applicant witnesses. So we can go off the record here. I think we're basically just checking in. Well, Coyne, we may have some did we have we may have some additional testimony here. So why don't we continue with a few more witnesses, see how long that'll take, and we can take a break if necessary after we proceed a little bit further. We've had a couple of breaks here, at least some interruptions. So let's plug on for a little bit more. So we'll have Cub go next, and who do we want to call first?
Let's just go in alphabetical order.
All right. That's
Cub calls Jeff Adams.
Sure, Narvi, if you could move your screen down a little bit so I can see your whole face. Specifically your mouth.
Is that better? I was probably just leaning forward a bit.
Okay,
just a little bit because it's covering your name is covering your face.
Oh, yeah. So based on what we see at your name tag is kind of on the bottom of that screen. So right now you're just above yeah, there we go.
There we go.
Perfect.
Thank you. I appreciate it.
Okay. All right. So I see Jeff Adams there. So I'll swear you in. Raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
All right. Go ahead, Attorney Narvi.
Thank you. Mr. Adams, did you submit direct rebuttal and surrebuttal testimony along with exhibits 1 through 6 in this proceeding?
Yes, I am.
And is the information in your written testimony and exhibits truthful and accurate to the best of your knowledge?
Yes.
If I asked you the same questions that appear in your testimony today, would your answers be the same?
They would.
Nothing further for Mr. Adams.
All right. Any cross? Oh, hearing none, you're excused. Thanks very much.
Cub's next witness is Dr. Steve Coyne.
All right. I see you there. Raise your right hand. Do you swear or affirm tell the truth, the whole truth, and nothing but the truth? You're muted still. I can do that from here. Oh, you got it.
I do.
Okay, there we go. Thanks.
Dr. Coyne, did you submit direct rebuttal and surrebuttal testimony along with exhibits 1 through 5 in this proceeding?
I did.
And is the information in your written testimony and exhibits truthful and accurate to the best of your knowledge?
Yes.
If I asked you the same questions that appear in your testimony today, would your answers be the same?
Yes.
Nothing further for Dr. Coyne.
All right. Thanks very much. Any questions for the doctor? Nothing. All right. Thanks very much. You're excused.
Thank you.
Cub's final witness is Corey Singletary.
All right. Raise your right hand. Do you swear or affirm tell the truth, the whole truth, and nothing but the truth?
I do.
Go ahead.
Mr. Singletary, did you submit direct rebuttal and surrebuttal testimony along with exhibits 1 through 4 in this proceeding?
I did.
And is the information in your written testimony and exhibits truthful and accurate to the best of your knowledge?
It is.
If I asked you the same questions that appear in your testimony today, would your answers be the same?
Subject to the corrections directed by the ALJ, yes.
Okay, nothing further for Mr. Singletary.
Okay. So I wanted to note for the record that I did strike Singletary 3 because it duplicates Cub Adams 5. So if you could, so that part of that correction, Singletary direct, is to just replace that citation Singletary 3 to Adams 5. So so if that's you know, I believe that's an accurate substitution. If it's not, let me know, but that's what I would expect to see happening there.
Understood. Thank you.
Okay. All right. So any cross for witness Singletary? All right. Thanks. You're excused.
Thank you.
Okay. So we can take local 953, witness Weber. See you there. You just need to unmute. There we go. All right. So raise your right hand. Do you swear or affirm tell the truth, the whole truth, and nothing but the truth?
I do.
All right. So state your name for the record, please.
My name is Nick Weber, W-E-B-B-E-R.
All right. And you're representing the IBEW local 953, is that correct?
That's correct.
Right. And you filed a surrebuttal testimony. Is that right?
That's correct.
And is that testimony complete and correct to the best of your knowledge?
It is.
Did you have anything to add based on what you've based on the surrebuttal testimony or anything you've heard so far today?
We do not.
Okay. So so I can accept your testimony. There's been no objections to it. I did want to point out I don't believe you've appeared before us before.
That's correct.
That's right. Yeah. And I just wanted to mention, again, like I said, no objections, but I did want to note that your surrebuttal testimony does respond to the applicant's initial proposal. in the sense that I believe, if I can recall this correctly, so you're responding to the rebuttal of the applicant, but also introduce your position on the original applicant proposal. I don't know if sure if it has to do with that differential between the 7 and 10 in terms of the union head count. I just wanted to point out though that if you in the future, if you do have a position that you'd like to make on the original proposal, you'd want to put that in your direct testimony, and then rebuttal or surrebuttal is simply responding to that prior filing. So you'd only be responding to the rebuttal in surrebuttal. So I read some of that to kind of blur that line a little bit. So just to keep you aware of that in the future, you really shouldn't be dropping back to the original filings there. So so if it is useful to get your position on the application or on staff's on the application, yes, if you wanted to file that as your direct testimony. So.
Understood. Thank you.
All right, great, thanks. All right, so with that, I can accept the testimony and any questions for the witness? Nothing? All right, thanks very much. You're excused.
Thank you.
All right, let's keep going. We have Renew.
Your Honor, Renew calls Mr. Belkkey.
All right.
Good afternoon, Mr. Belkkey. Can you state your full name for the record?
Let me swear him in first, and then we can
Sorry about that.
All right, so raise your right hand. You swear or affirm, tell the truth, the whole truth, and nothing but the truth.
I do.
All right, I was a little slow on the trigger there. You might want to speak up a little bit. You're just it was hard for me to hear you. I don't know. Hopefully everyone else can.
Okay. Can you state your full name for the record?
Yes, Ben Belkkey, Behlke.
Mr. Belkkey, did you file or cause to be filed direct testimony, rebuttal testimony, surrebuttal testimony, and 4 exhibits?
Yes.
Is the information in your testimonies and exhibits complete, correct, and truthful to the best of your knowledge?
Yes.
Do you have any changes you wish to make to your testimony at this time?
I do not.
Your Honor, Mr. Belkkey is ready for cross.
All right, thanks. Any questions for the witness? Nothing. All right, thanks very much. You're excused.
Renew calls Mr. Kell.
All right, I'm going to quickly swear you in. Do you swear or affirm, tell the truth, the whole truth, nothing but the truth?
I do.
All right, go ahead.
Good afternoon, Mr. Kell. Please state your full name for the record.
Andrew Kell, Kell.
Mr. Kell, did you file or cause to be filed direct and surrebuttal testimony and 3 exhibits?
I did.
Is the information in your testimony and exhibits complete, correct, and truthful to the best of your knowledge?
Yes, the information is true and correct.
Do you have any changes you wish to make to your testimony at this time?
No, I do not.
Your Honor, Mr. Kell is ready for cross.
All right, any questions? None? Thanks very much. You're excused. Let's continue with Walmart.
Walmart calls Eric Austin.
Okay, I see you there. So I'm going to unmute you. There we go. All right, raise your right hand. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth? All right, I'm having a little trouble hearing you, so if you just get closer to the mic.
Sure, I do.
Perfect. All right, thanks. Okay, go ahead.
Please state your name for the record and spell your last name.
Eric Austin, Austin.
Are you the same Eric Austin that caused to be filed a written direct testimony in exhibits 1 through 7?
Yes, I am.
Is all of the information contained in your direct testimony and exhibits complete and correct to the best of your knowledge?
Yes.
And if I asked you the same questions that appear in your testimony today, would your answers be the same?
Yes, they would.
Thank you. Your Honor, Mr. Austin is available for cross.
All right, any questions for the witness? Hearing none, you're excused. Thanks very much.
Thank you.
Right, so we're going to take witness Pollock by affidavit. We're having verified by affidavit. And so if staff's ready to go, we can keep going. All right.
Your Honor, the commission calls Justin Adams to the stand.
All right. See you there. Raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
All right.
Please state your name for the record.
My name is Justin Adams.
And did you prepare and file or cause to be filed direct testimony, surrebuttal testimony, and one exhibit in this docket?
I did.
Are the statements and representation in the testimony and exhibits you filed in this case true and correct?
They are.
And aside from any typographical errors noted by the judge, do you have any additions or modifications to your testimony or your exhibit at this time?
I do not.
Your Honor, the witness is available for cross.
Okay, any questions? None? Thanks very much. You're excused.
Thank you.
Your Honor, the commission calls witness Keano to the stand.
Hi there. I'm going to unmute you and raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right, go ahead.
Please state your name for the record.
My name is Kaylee Keano, Chiono.
Thank you. And did you prepare and file or cause to be filed direct and surrebuttal testimony and 4 exhibits in this docket?
Yes, I did.
And are the statements and representations in the testimony and exhibits you filed in this case true and correct?
Yes.
And do you have any additions or modifications to your testimony or your exhibits at this time?
No.
Your Honor, the witness is available for cross-examination.
Any questions? Hearing none, you're excused. Thanks very much.
The commission calls staff witness Fischer to the stand.
There's witness Fischer. All right, well, I'll swear you in. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
Yes, I do.
Okay, go ahead.
Thank you. Please state your name for the record.
Andrew Fischer, Fisher.
Did you prepare and file or cause to be filed direct testimony, surrebuttal testimony, and 2 exhibits in this docket?
Yes.
And are the statements and representation in the testimony and exhibits you filed in this case true and correct?
Yes, they are.
And do you have any additions or modifications to your testimony or exhibits at this time?
I do not.
Your Honor, the witness is available for cross-examination.
Just want to confirm with the witness, we're expecting the fuel cost update exhibit to come in after the hearing.
I believe that's correct.
Yeah, that's something that you would prepare. I marked it Fisher 3, so I just want to make sure that's something we're expecting you to file. I thought that's what was in your testimony, but maybe I'm wrong. That's why I'm asking.
I'm not sure actually. I would probably need to ask someone else about that.
I believe witness Klaus Milada will be filing that.
Okay.
Oh, right. Why did I put it as Fisher? I'm not really sure. Okay. Sorry about that. Yes, I can make that adjustment. Sorry. Okay. Anyway, let's move on. Any questions for the witness? No? All right. You're excused. Thanks very much.
Thank you.
The commission calls staff witness Griffin to the stand.
All right. See you there. Raise your right hand. Do you swear or affirm tell the truth, the whole truth, and nothing but the truth?
Yes.
Okay, go ahead.
Thank you. Please state your name for the record.
Eric Griffin.
And did you prepare and file or cause to be filed direct testimony, surrebuttal testimony, and 2 exhibits in this docket?
Yes.
Are you also sponsoring the staff data request exhibit?
Yes, I am.
Are the statements and representations in the testimony and exhibits you filed in this case true and correct?
Yes, they are.
And do you have any additions or modifications to your testimony and exhibits at this time?
No, I do not.
Your Honor, the witness is available for cross-examination.
Okay, any questions? Nothing? All right, thanks, you're excused.
The commission calls staff witness Horry to the stand. Oh, wait, I'm sorry. Can we recall witness Griffin for just a moment? I have to have him verify one more exhibit.
Oh, yeah, sure.
Sorry. Do we need to swear him in again?
No, you remember, you recall you're under oath, yes?
Okay. Did you also sponsor, or are you also sponsoring the staff comments exhibit in this docket?
Yes, I will be sponsoring the public comment exhibit.
Thank you. No further questions.
All right, great, thanks.
The commission calls Mitch Horry to the stand.
Okay, I see you there. Raise your right hand. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth?
I do.
Okay, go ahead.
Thank you. Please state your name for the record.
Mitch Horry.
And did you prepare and file or cause to be filed direct testimony and 1 exhibit in this docket?
Yes.
Are the statements and representation in the testimony and exhibits you filed in this case true and correct?
Yes, with 1 correction.
And what would be that correction?
On page 4 of my direct testimony, beginning at line 10, I state that the applicant's request to fund and operate voluntary energy efficiency programs in 2026 in docket 4220 EE 2026 remains subject to commission approval. I would like to correct this statement to note that the applicant's request to fund and operate voluntary energy efficiency programs in 2026 was approved by the commission at its open meeting of September 11th, 2025, and the final decision for this approval has yet to be issued.
Thank you. And other than that, do you have any other additions or modifications to your testimony or exhibit at this time?
No, I don't.
Thank you. The witness is available for cross-examination.
Okay, so I'll just note that we'll just accept that as spoken testimony stated at the hearing. We won't need to update the written filing as it was filed before the commission decision that the witness just cited. So, but that's great. So any cross-examination for this witness? No? All right, thanks very much. You're excused.
Thank you.
Thank you. The commission calls witness Milada to the stand, please.
Hey, there we go. I was going to say, I don't really see you there. All right, raise your right hand.
Just my hair.
Just not so hard to miss. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I will.
All right, go ahead.
Thank you. Please state your name for the record.
Klaus H. Milada.
And did you prepare and file or cause to be filed direct testimony, surrebuttal testimony, and exhibits in this docket?
I did.
And are the statements and representations in the testimony and exhibits you filed in this case true and correct?
They are.
And do you have any additions or modifications to your testimony or to your exhibits at this time?
I do not.
Thank you. Your Honor, the witness is available for cross-examination.
Okay, any questions for the witness? None? Thanks very much. You're excused.
The commission calls witness Swatulski to the stand.
Okay. There we go. All right, raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
I do.
Okay, go ahead.
Thank you. Please state your name for the record.
Nicole Swatulski.
Did you prepare and file or cause to be filed direct testimony, surrebuttal testimony, and 2 exhibits in this docket?
I did.
And are the statements and representations in the testimony and exhibits you filed in this case true and correct?
They are.
And do you have any additions or modifications to your testimony or to your exhibits at this time?
No.
Thank you. Your Honor, the witness is available for cross-examination.
Are there any questions? Hearing none, you're excused. Thanks very much.
Great. And last but not least, the commission calls witness Vesperman.
All right, I see you there. I'm going to unmute you from my end, and I'll swear you in. Raise your right hand. Do you swear or affirm, tell the truth, the whole truth, and nothing but the truth? Okay, I'm still not hearing you. Let's go off the record for a second. Yeah,
I do.
There you go. It's those tricky headsets. Okay.
Yes.
So, so on the record, we can. Well, let's just confirm one more time while we're on the record that you're sworn in. One more, I do.
I do.
Okay, great. I can also forget it. Okay, so anyway, not enough. It's too late for jokes. So you're sworn in. Let's go ahead with the witness.
Thank you. Please state your name for the record.
Kevin Vesperman.
And did you prepare and file or cause to be filed direct testimony in this docket?
I did.
And are the statements and representations in the testimony you filed in this case true and correct?
They are.
And do you have any additions or modifications to your testimony at this time?
I do not.
Thank you. Your Honor, the witness is available for cross.
Okay, any questions? Hearing none. Oh, anything? No. Hearing none, you're excused. Thanks very much.
Thank you.
Okay, so I think we have all of our witnesses checked in. We do have our post-hearing schedule already set in the scheduling order. So we'll be expecting the refilings according to that schedule, and of course, you know, the rest of what's indicated in there in terms of transcript corrections or and the briefs. So at this point, not expecting anything else for this hearing, but do we have anything else we need to review before we adjourn?
Nothing from the applicant, Judge.
All right. Okay, so I believe that's it. Thanks very much, everyone. Take care, and we're adjourned.
Thank you.
Thank you.
Thank you, Your Honor.
Thank you.